grateful to the team at Corruption Watch for the chance to be part of this conversation. Today's subject is one of the quietest threats to transparency in Ghana, the cost of information. We have a Right to Information Act, and that is supposed to make public information accessible to ordinary citizens. But more and more, public institutions are attaching price tags to that information that put it out of reach. Organizations like the Electoral Commission, the Office of the Registrar of Companies, and other bodies are leaning on one law or another and demanding fees that most Ghanaians simply cannot pay. So I want to talk about how we got here, why it matters, and what we can do about it. Let me start with a case that some of you may remember. Back in 2018, the Citizen Ghana movement and I went to court to compel the Electoral Commission to furnish us with the annual audited accounts of all 24 registered political parties. That case was actually the second in a series of cases the Citizen Ghana movement, CGM, and I brought to advance transparency and accountability in Ghana. The first was the groundbreaking bus branding case, where the High Court affirmed the constitutional right to information for the very first time. In that case, the court directed the minister to give us copies of all documents relating to a government contract for the branding of buses, and directed the minister to charge us a fee of only 1,000 Ghana cedis. We brought the Electoral Commission case to build on that first win. We wanted to help develop the law on the right to information and to compel a public body that had failed to collect records to do its job, to gather the accounts that it was supposed to gather from political parties and to make them available to the public. And we won. The EC published the list of which political parties had complied with their obligations to file audited accounts and which had not. But the part that matters for today's conversation is that looking back, what happened after we won was a warning sign. It was a harbinger of the very problems Corruption Watch journalists and others in the media are running into right now. The first challenge was simply enforcing the judgments. It took several months after the court ruled in our favor for the EC to comply. The first challenge was simply enforcing the judgments. It took several months after the court ruled in our favor for the EC to comply. We kept writing to them. We used back channels. At one point, we even considered threatening a second lawsuit. And then finally, they came back to us with a fee. I don't remember the exact amount, but I remember thinking even then that it was high. And what troubled me more was that the Electoral Commission could not justify the fee on any objective basis, whether that was the cost of paper, the time spent scanning and printing, or the fair market value of the work. There was no rational basis for that number. And when we finally received the documents, many of them were of poor quality. So this trend we are seeing now, exorbitant fees set with no real basis, the EC began that many years ago. And unfortunately, it has continued, even after the Right to Information Act was passed, and even after that act set specific fees. These high charges defeat the entire purpose of the act, which is transparency, because they make information practically impossible to obtain for most Ghanaians who simply cannot afford these fees. Now, people ask me two things often. Was the information we sought actually released, and did we have to pay for it? Yes, the information we sought from the EC then was released, but in two parts. First, the EC published a record of which parties had filed their accounts and which had not in the daily graphic, and that was free and available for everyone to see. And secondly, the EC handed over the actual accounts themselves, but for that they charged us per document. Again, I can't recall the exact figure, but it was exorbitant. At the time, CGM and I made a deliberate choice. Rather than going back to court to fight the fee, we paid it because we judged that challenging the fee would take several more months, cost us legal fees, and that it will be more important to get the data into the public's hands quickly and publish it. So we paid the fee and obtained the information. This brings us to what is happening today with the Electoral Commission, with the Office of the Registrar of Companies and other state and government bodies. I don't know exactly how many pages of information were requested in each case, so I cannot say with precision whether every fee complies with the schedule set out in the Fees and Charges Act of 2022. But at first glance, these demands look exorbitant. The Electoral Commission is asking for more than 9,000 cedis for the audited accounts of political parties. Another institution, GMET, I understand, has asked for more than 14,000 cedis for rainfall and weather data. These amounts are simply too high for ordinary Ghanaians or independent journalists and media houses to pay. To put the fees in context, the figures being charged are higher than the living wage in Ghana, the average living wage in Ghana, which is estimated at around 5,700 cedis a month for an average family. The entire point of the Right to Information Act is to make it easier for Ghanaians to access public information, especially when that information is in the public interest. To pay over 9,000 cedis that the EC is charging, a Ghanaian family would have to set aside almost 2 months of their living wage. That clearly puts the information out of reach for most people. And beyond being unaffordable, these charges appear to breach the law itself. Now, I should be transparent. I am not called to the bar in Ghana, but having read the Fees and Charges Act, Section 1 of that Act explicitly removes the power to levy fees under the Electoral Commission Act of 93 or under the Ghana Meteorological Agency Act, and in its own words, under any other enactment, and transfers those powers to the Minister of Finance. To cover every base, Section 5 transfers the power to set fees under any other act, any other law, like I stated earlier, to the minister as well. So the Electoral Commission, I understand, has pointed to the Political Parties Act as the basis for its charges. But as the Corruption Watch team has rightly noted, that act does not actually provide for any fees. And even if it did, the power to set fees no longer belongs to the Electoral Commission. That power has now been transferred to the Minister of Finance under the Fees and Charges Act. The Electoral Commission's reference to the Political Parties Act raises an obvious question. If the RTI Act, which sets charges and fees, conflicts with another law that imposes fees, which law should be prioritized? Ultimately, that may be a question for the Supreme Court of Ghana to settle, but a Supreme Court case takes many months, and people need information now. So let me suggest a few more immediate steps. First, the Minister of Finance and Attorney General could jointly circulate a memo reminding every ministry, department, and agency that the Fees and Charges Act is still in force and that only the Minister of Finance has the power to set fees for the provision of information under that law. That same memo could spell out explicitly the fees that apply to right to information requests, so there's no room for confusion. Second, the minister can set up a clear mechanism for members of the public who are overcharged to lodge a complaint and to make sure that those complaints are actually addressed. And finally, there should be consequences for breaching the Fees and Charges Act. The minister should impose some form of sanction on other ministries and agencies that break the law, because without any sanction, there's little reason for them to stop charging these unauthorized fees. We could also look at how other countries have handled the matter of charges for information. Under Americans' Freedom of Information Act, which is the equivalent to the Right to Information law in Ghana, agencies can charge fees to locate and produce documents, but there are important protections. Agencies are barred from charging for the first 100 pages of duplicated documents where the request is not for commercial use and comes from the news media or from an educational institution or a non-commercial scientific institution. On top of that, anyone requesting information can apply for a fee waiver if they can show that releasing that information is in the public interest, that it is likely to contribute significantly to the public's understanding of what the government is doing, and that the information is not primarily for the requester's own commercial gain. That is exactly the balance we are missing in Ghana's system. The American system recognizes that when journalists or the public are seeking information to hold government accountable, cost should not be a barrier. So if I were to suggest one key change, one change to make sure access to information in Ghana does not become commercialized, it would be this. Parliament should amend the Right to Information Act to provide for a similar public interest fee waiver, so that when information is genuinely in the public interest, the fee for producing it can be set aside. Alongside that, the Minister of Information should work with ministries, departments, and agencies to publish more of this information online proactively. Ghanaians should not have to file a request and pay for hard copies of political parties' records from years ago, when that information could simply be posted online for anyone to see. Let me close with this. A right that you cannot afford to exercise is not really a right at all. The Right to Information Act was meant to open the doors of government to ordinary Ghanaians. If we allow public institutions to quietly price those doors shut, we don't just lose access to a few documents, we lose a tool in the fight against corruption. My thanks to Corruption Watch, to Joy FM, and to everyone working to keep the fight alive. Thank you.
Africa money, I got the chop on.